Magandang hapon, this is Trixie Cruz-Angeles for Luminous by Trixie Cruz-Angeles and Ahmed Paglinawan na Facebook page. Ang topic natin for today, dahil napakinggan ko, hindi pa po tapos ang pagpapakinig ko dun sa Senate hearing today on Republic Act 10592 at yung almost, or sinasabi sa karambola na near release ni dating Kalawan Mayor Antonio Sanchez. Sabi ni Secretary Maynard Guevara, and this is a very important point, kasi marami sa atin nagsasabi na para dito sa mga katulad ni Mayor Sanchez, hindi dapat nag-a-apply yung batas. Gayunpaman, we understand that, kailangan talaga hindi nag-a-apply yung batas para sa mga katulad sa kanila. Ngunit dito sa wall na ito, na-point out natin na ang malabo ang Section 1, or at least ito yung stand ni Secretary Maynard Guevara, is malabo ang pagka-draft ng Section 1 para magamit ito bilang dahilan na hindi i-include ang mga heinous crimes. Okay, maraming umaaway sa, hindi naman marami. May ilang-ilan na mga umaaway sa akin dito sa Facebook at nagsasabi na ang intention daw ng batas ay hindi mag-apply ang heinous crimes. Hindi po totoo yan. Kasi maliwanag, bago tayo mag-interpret ng batas, based on the intention, kailangan hindi maliwanag yung pagkakadraft. The problem is, maliwanag yung pagkakadraft. Let me just distinguish. Sinabi ni Secretary Maynard Guevara, vague yung batas. Vague in the sense na kung gagamitin natin basihan yan para hindi isama ang mga convicted for heinous crimes, malahabo. Kasi maliwanag sa Section 1 na ang inaamyendahan ng buong section na yan ay Section 29 ng Revised Penal Code. At dahil Section 29 refers only to those who are preventive imprisonment or provisional imprisonment, ibig sabihin, ito yung mga nasa kulungan habang nagtatrial pa lang sila. Okay? Kung gusto ninyo na mas detalyadong explanation, nandun po sa wall, nakalagay doon kung bakit hindi siya dapat mag-a-apply. A plain reading of the law means that it will not apply nga. Yung mag-a-apply talaga yung good conduct time allowance doon sa mga na-convict na for heinous crimes. And this is the reason kung bakit in 2014 nag-umpisa na po na mag-release ng mga convicts who were deemed worthy or who had received good conduct time allowances. Maraming problema ang batas. Problema only in the sense na suddenly when we're looking at it, nakikita na natin na masyadong madali para makakuha ng good conduct time allowance. Bakit? Base dun sa manual on the good conduct time allowance dito sa na-inissue ng Department of Justice in 2017, anong definition ng good conduct? Ang good conduct nakalagay doon ay simple lang, non-violation of the rules. So, ibig sabihin, and since the Section 2 of the law prescribes na ang pag-determine ng good conduct is on a monthly basis, yung good conduct is determined per month. So, if in 1 month, nag-abide ka by all of the rules, you did not get into trouble, and then may dagdag pa yan na good conduct if nagtuturo ka or may mentoring program or nag-aaral ka or all that, during the month of that incarceration, you get an additional so many days off. Okay? So, ano yung problema natin dito? The plain reading of the law will say that hindi talaga kasama, a plain reading of the law will say hindi kasama ang computation ng good conduct time allowance only for those who are detained while waiting trial or while undergoing trial. Pero once convicted ka na, then the plain reading of the law will say that you can apply for good conduct time allowance. Huwag kayong sa akin magalit kasi binabasa ko lang yung batas. Daming hanash eh. Ito talaga, tingnan nyo yung wall ko, maraming nagpipilit. Hindi, kasi ang intention ng batas, yada, yada, yada. But before you go into the intention of the law, you first have to look if the law, how it's going to be applied just by the plain reading of the law. Okay. Next, sinasabi, so ngayon, may mga ito na po, yung kalakaran, kahit noon pa, yun din ang sinasabi ni Secretary Guevara. Ang problema po, kaya namin ginawa yung ganito kasi ganito na siya noon. Ganito na yung kalakaran since the time they started implementing the law, at ang nagbago lang po ay ang sinabi ng Korte Suprema nung June only of this year na mag-a-apply ito sa mga for those convicted prior to the law in 2013. Okay? Anong ibig sabihin yan? Kahit na-convict ka, let's say, in 1987, etc., mag-a-apply ito. So, kung hindi pa tapos yung service mo ng 40 years, let's say that you have the maximum, heinous crime pa rin, or life sentence, or reclusion perpetua to death, ang hatol dun sa iyo, na wala yung death penalty, so downgraded ka to reclusion perpetua, and let's say you have 40 years, yun ang hatol sa inyo. Hindi mababawasan yung time that you spent in jail. Hindi po yan mag-a-apply dun sa good conduct time allowance. Walang evaluation for that. But once you are incarcerated and believed on having been convicted by final judgment, at effective na yung final judgment na yon, then dun mag-uumpisa yung pag-i-impose ng good conduct time allowance. Okay, so ganun na nga nangyari. By 2014, merong ilang mga drug lord na pinakawala ni Secretary Laila de Lima. And ito, napansin niyo dun sa hearing, ay walang question. They were released base dun sa isang order ng Secretary of Justice. Ulit pong sinasabi ni Senator Gordon na bakit merong mga na-release without an order from the Secretary of Justice dito sa time ni USEC file doon. Maliwanag na during the time of Secretary de Lima, siya mismo ang pumupirma ng mga early releases due to good conduct time allowance applications. Okay, so yan na nga, may mga napakawala na. Ang sinasabi ng iba, evaluate natin para pwede natin ibalik sila. Wait, sabi ni Secretary Maynard Guevara, we consider of course the rights of the victims. Okay? So, may mga biktima dito because these are, the heinous crimes usually have some kind of damage on a private complainant. Merong pribadong tao or may tao na naagrabyado, may tao na nasaktan, may tao na nawalan. So, murder, rape, kidnappings, destructive arson that involved the death of a person or serious physical injuries, etc. Plunder. So, except for plunder kasi walang private complainant. So, dun sa sa mga crimes na merong nadihado, merong nasaktan, merong naulila, etc. Yung mga yon, we of course would like to respect the rights of the victims' families. At syempre, the rights of society because we want to be protected against people who are prematurely released nang hindi pa sila fully rehabilitated. And there is the term. Tatlo ang basihan para sa ating criminal justice system. One is to penalize, ibig sabihin to punish the accused. The second is to protect society. Tatanggalin natin yung taong yon from society to prevent society or our people from being hurt or harmed by this person. And the third objective of the criminal justice system is reformatory. Ibig sabihin, there are people who can be rehabilitated, people who can still learn. So you put them in jail and then you institute a program for rehabilitation so that he can go back to society, join it as a productive member, and not harm anybody. Eto yon. So dun sa third, kasama yung good conduct time allowance. Yun ang pinupuntiryan ng good conduct time allowance with special time allowance for those who are undergoing mentoring programs, etc. or who are going to school. Yan yung reformatory aspect ng batas. So, ibig sabihin, on the third directive, dun sa third na objective para dun sa criminal justice system natin, pinupuntiryan natin that they can get time off from good behavior if they have shown that they can be rehabilitated and can rejoin society. Kaya ba natin? Kaya ba ng tao na yon? So, ang kailangan doon is merong evaluation to determine kung yung tao na yon ay pwedeng ibalik. Doon sa Board of Pardons, sa procedure sa Board of Pardons and Paroles, yun po yung sole determination. Nag-reform na ba itong taong to? Maaari ba natin itong isoli sa lipunan nang hindi na siya nakakakommit ng harm, na hindi na siya makakasakit, at magiging productive member of society uli siya? So yun ang punteriya ng Board of Pardons and Paroles. And take note na the Board of Pardons and Paroles is the one that makes the last assessment before that person receives an order from the Secretary of Justice to be released. Okay? Hindi po yung Bureau of Corrections Director General. The Bureau of Corrections Director General and other officials form a committee after pagka na pwede nang i-release based dun sa computation ng warden, i-forward yung records to the Bureau of Corrections. Tapos dun sa Bureau of Corrections merong committee, at yung committee na yun i-evaluate nila yung computation ng good conduct time allowance. Please take note, ayon dun sa batas, once the good conduct time allowance has been granted, walang bawian yan, and that is section 5 of the law. So maliwanag yan. Once awarded, walang bawian yan. Ibig sabihin, even if he does something bad after the month that he has been granted so many days off, hindi po mababawi ng later on bad behavior ang na-awardan na good conduct. And there is no way that the prison officials making an evaluation of this person can take away good conduct time allowance that has already been granted. Now, take note of that provision because this now becomes problematic kapag ni-release natin yung tao. Okay? Okay, so the records now go to the Board of Pardons after the committee evaluates the computation of the good conduct time allowance and the affirmation that this person has good conduct. Aakyat yan sa Board of Pardons and Paroles. Doon sa Board of Pardons and Paroles, merong investigative. The Pardons and Paroles Administration will conduct an investigation into the person allegedly deserving of good conduct time allowance. After that investigation, the Board of Pardons and Paroles will determine and award and make the recommendation for the approval of the application of good conduct time allowance, and then this goes to the Secretary of Justice. Now, here's the problem. During the time of Director General Faildon, there are some people allegedly who signed release orders nang hindi umaakyat siya sa DOJ. The obligation for the records to go up to the DOJ is contained in the manual issued in 2017. Pero bago ang 2017, hindi ako sure kung yun na po yung patakaran. So, it's possible na 2017 lang yon. Kaya nasana yung ibang mga officials na noon pa, sila na yung pumipirma kahit hindi si Director General ang pumirma ng release order or kahit walang order from the Department of Justice. But that's merely an administrative concern. Nevertheless, nag-point ng isang okay, muntik na akong maligaw. Now, after the person has been released, he now has what we call a vested right. So, dalawa yung vested rights dito na pinag-uusapan natin. One of the vested rights is the grant of good conduct time allowance na nakalagay sa Section 5 of Republic Act 10592. Okay? Pangalawa is the vested right of being released. Kasi once na-grant na, in-apply yung GCTA, and the law itself says na extinguished na yung criminal liability at the part where the good conduct time allowance has been granted, then at that point, especially when you're released, you're considered to have what we call a vested right. Why? Because the right is to be free. The right is mobility. The right is not to be incarcerated. But the jail, to impose a penalty requires what we call due process. Kasi sabi ng saligang batas natin, no person shall be deprived of life, liberty, or property without due process of law. And when you take away a right, take away what is already a vested right, you have to go through due process again. Now, here is the problem. When it comes to criminal laws, kailangan ang pagkabasa natin ng batas ay naaayon doon sa pabor ng akusado. Okay? Yes, that is a doctrine. That is a doctrine in criminal law. Matagal na po yan. Ang ating revised penal code ay nagsimula noong 1930 pa lang. At inadapt natin ang buong buo sa Kodigo Penal ng Espanya back in 1898. I think 1898, but I'm not sure of the year. Nevertheless, the Spanish Código Penal and the Código Civil, by the way, were adopted into Philippine law. Okay? Now, what does Secretary Guevara say? And I agree with him. There are now two rights that are in contention, the rights of the victims and the rights of the accused. But under the law, the rights of the accused will take precedence when the law is clear. And when the law is clear that a right has already been vested. So, ibig sabihin dito, nakamit na nila yung kalayaan nila. May good faith dun sa pagbabasa ng batas. Ang good faith, lalong-lalo na on the part of the Bureau of Corrections, dahil sila lang ang taga-implement. Lalong-lalo na kung may order from the Secretary of Justice to release, and this is what a memorandum order means. A memorandum order means remember. That's why memo siya. From the root word to remember. And a memorandum order is issued reminding an official of his obligation. So in this case, may order from the Secretary of Justice, memorandum order is now issued by the Bureau of Corrections to the warden para ma-release ng warden yung incarcerated prisoner. Okay? So, yan uli. So, between the two rights, definitely mabigat yung karapatan nung akusado, nung convict, because as far as he is concerned with the plain reading of the law and based on the constitutional guarantee of due process, napakawalan na sila. Now, sinasabi ni Senator Drilon, meron siyang nakitang isang kaso involving involving a prison director. Jail warden. Yung isang warden, nagkarayot dun sa isang jail, yung isang preso, kinuha ng warden kasi sugat-sugat at pinastay niya doon sa ibang jail. Hindi niya, because he had severe injuries. 1 year na lang siya remaining in his sentence. Sinabi nung original kung saan siya dapat na-incarcerate, dapat isoli na siya doon sa dapat niyang kulungan. Pero kinip siya ng jail warden somewhere else kasi ang sabi niya may injuries yung tao na yon, and he will be kept there until the injuries have healed. Yun lang nga, ano nangyari? Hindi pa completely daw healed, natapos yung 1 year, so ang ginawa, ni-release siya nang walang release order from the penitentiary. There was no release order from the Insular Penitentiary. The Insular Penitentiary was the precursor of what is now the Bureau of Corrections. Kasi yun yung national, kaya insular. So, walang order from the Insular Penitentiary. Nag-file ng, this was a petition for co-warranto, if I'm not mistaken. Ni-reverse yung decision nung warden at pinabalik yung preso. Bakit? Kasi walang basihan, whether sa batas or sa rules, yung pag-keep nung preso na yon dun sa lugar ng warden na respondent dito sa kaso. And so, hinanap yung tao na yun at binalik daw sa kulungan. Lower court lost jurisdiction, directed to incarcerate the appellee to the National Penitentiary. So, supposedly, makakawala na dapat siya, pero ang order ng Korte Suprema, isoli siya doon sa penitentiary na pinagkuhaan yan. Ang sinasabi ni Senator Drilon, we can apply this case to the case at hand na nagkamali dun sa application ng batas, and therefore we should go after everybody who has already been released under this law, particularly those who are who were convicted of heinous crimes. Problem. Sure na sure ako, as soon as the DOJ does that, then those who have been released will go up to the Supreme Court. But that's actually good news kasi at least ang Korte Suprema ang magdedetermine kung tama ba ang ginawa ng DOJ. I have high hopes with the Supreme Court, number one, because they'll be able to read this law so that it will benefit everybody. Okay? So, okay. Ayoko nang i-discuss kasi yung mga hanash ng ibang mga senators because they might not be relevant to the topic here. I'm going to check your comments now. Sabi ni Daddy Diggs, my president, Marjorie Andrews, Drilon at Pangilinan, hindi kinaya, ililampas sa Senado ni SOJ Guevara, sobrang galing. That is true. Sabi ni KGBP, bakit dinidiin ni Gordon na dapat may discretion si Fildon sa batas over the implementation of the law? Hindi ko po alam kung bakit ganun yun. I'm supposing that well, Senator Gordon is actually a good litigator. He was trained in ACRA. Meron kasing, checkin ko rin, merong isa pang tanong dito, si Mark, hinahanap ko yung tanong ni hi Mark, kasi nanonood siya, tsaka si Madam Mocha. Sabi daw ni Senator Recto, and I didn't catch this part, that's why mahalaga para sa akin yung tanong ni Senator Recto. Yung pagkakabasa ni Senator Recto, wala daw provision for actual release kung di computation lang. I think this is incorrect because maliwanag dun sa Section 2 that the extinguishment of criminal liability happens in 3 instances: commutation, service of sentence, at saka yung application of good conduct time allowance for those portions where it applies. So, bali yung pagbawas ng good conduct time allowance is also what we call an extinguishment of criminal liability. Ang criminal liability po ay yung penalty na sinaserve. So in this case, yung penalty na sinaserve ay pagkukulong. So yung extinguishment of criminal liability means that you have finished the service of your sentence and therefore you must be released. Now, here's where Secretary Gonzalo was also, how do you call this? Brilliant, because he was able to point out not only with vested rights, but that as soon as, if you keep a person in jail for longer than his sentence, the person who is keeping him in jail will be subject to illegal detention. Okay? This is no longer about nonfeasance, malfeasance, etc. It is about illegal detention, and they can be subjected to a petition for habeas corpus or a criminal case for serious illegal detention. Okay? So, yun. So, what's the problem now? The DOJ and the Bureau of Corrections has a problem. The law the plain reading of the law says that they have to release these people. Pero ang daming galit. What are they going to do? If they keep these people beyond the period of their penalty, they will be liable for serious illegal detention or serious legal detention, which in plain layman's language is kidnapping. Okay? Hindi mo kasi pinapalaya yung tao na dapat lumalaya na. On the other hand, if it is somebody like a monster that we all know and we don't want to name, if it's a monster and you want to release him back into an unsuspecting public, then we also have a problem because we are not sure if reform has already applied to him. Diba? Has he been reformed? Has he been, we're not privy to the evaluation process. Hindi natin nakita kung ano yung dahilan ng Board of Pardons and Paroles, kung bakit nire-recommenda nila na makalaya na itong taong to. Tapos na ba siya? Doon sa kanyang, nagbago na ba siya? Is he a changed man? At dito, tinitignan ko yung mga comments ni Senator Bato. Remember, Senator Bato was also with the Bureau of Corrections and he might be coming from the stand of personal knowledge na ang sinasabi niya is baka nagbago na nga itong si Mayor Sanchez. Regardless, there's still intense public outcry. I disagree kasi. But with the public outcry about the release of this person, it is necessary to show kung ano yung naging basihan ng Board of Pardons and Paroles. Sabi ni, ang dami ako nadaanan. Sabi ni Daniel Bryan, are the calls of the Senate members for USEC Fildon justifiable? Isa lang ang nakita ko nung sinabi ni, and I thought it was intensely rude for Senator Risa Hontiveros to say, USEC Fildon, kailan ka magre-resign? One, he does not serve at her pleasure. He serves at the pleasure of the President. And it is the President who will determine whether he should continue in such service. Pangalawa, It was intensely rude because it was not called for at any point in the Senate hearing. Third, she completely disregarded the fact that Yusek Faldon was merely implementing a law passed by the Senate that she belongs to, the Senate, the chamber that she belongs to. Bakit? Base dun sa history nitong bill na ito, nitong batas na ito, merong House version at may Senate version. Yung House version was authored by by now Senator Sani Angara when he was a congressman. But according to him, the only intent of the House bill was for the good conduct time allowance to also apply to the period of incarceration before conviction. Yung time na nakakulong bago pa sila na-convict. Doon sa Senado, itong batas na to, ang buong bill na sinubmit sa Senado. I'm not sure kung sponsor lang si Senator Honasan at saka si Senator Miriam, pero apat ang names na lumilitaw doon sa original House bill: Honasan, Villar, Escudero, and Defensor Santiago. At yung kanilang bill po ay naipasa ng buong buo. Walang changes, in-adopt po ng House, kaya walang bilateral conference dito. And so, diretso na to, after the Senate bill passed, then President Noynoy signed it into law. So, sabi ni Jonsu, wala ngang objective measurements kung paano gine-grade ang good conduct, prone to abuse talaga yung GCTA. That is not true. Okay? Merong objective standard dun sa Manual of Operations, and it says non-violation of the rules, and that is an objective standard. Okay? Don't think that just because you want somebody, just because you disagree with the law, that you think that this is already bad law. No, I disagree. It's good law. The law is not actually vague. It's only vague because we want to apply it against those who have been convicted of heinous crimes. Okay, don't mistake the vagueness of a law or the vagueness of a provision to the vagueness of your intention to apply it to something that the law did not actually intend. Okay? Why am I saying that this law is good? I'm saying the law is good because one, it is valid. Two, there are valid. It's a valid subject. It complies with all the requirements of a valid law. Except, we disagree with its point. Diba? So, there is a reason kung bakit medyo sinikreto nila to. Sabi ni Jenny Alvarez, pwede po kayo mag-file ng case si Commissioner Faldon against sa mga senators, lalo na kay Lacson, dahil sobrang paninira, puro na lang yung mga bintang niya. Well, the way I see it is that Yusek Faldon handled himself relatively well. He had to rely on some advice, but he did well. He was calm. He did not, lose his temper. Did not get, angry over the questioning of Senator Lacson. So I think that's good. The problem with Senator Lacson is that he's imputing that a crime has been committed, and in fact that it has been committed by Undersecretary Faldon. But in order to do that, Senator Lacson will have to file a case and to file it with the Ombudsman. So doon na lang, kasagutan na lang sa hukuman. Sabi ni Mimi, thank you. Okay pa. Sabi ni Melvin Batucabe, shout out. Hi. Okay. Sabi ni Websay Tinimo, Bob, is it even fair in the first place to give convicts credit for good conduct? Hindi po ba ang mali din is yung Bucor? Kung wala silang nahuhuling bad conduct, hindi po ba ibig sabihin nun hindi effective ang Bucor? Yo! No, not Bucor. Warden po yan. Hindi yan trabaho ng Bucor. Bucor is supervisory over all the jails. And supervisory, meaning because they cannot be there all the time. Besides, ano ang discretion ng Bureau of Corrections, especially the Director General, when there is a manual, and the manual was passed before his time, nakalagay doon sa 2017 manual, na ang definition ng good conduct ay non-violation of the rules. Meron bang nag-challenge niyan? Wala. Pinalitan ba yan? Wala. So, i-implement mo yan. Because as far as the Bureau is concerned, these are valid rules. And this is a valid determination of what is good conduct. If you feel that it's not a good determination, then you file your case before the court and have it stricken down. That's how the justice system works. Sabi ni Carl Alexis Dasco, kung yung manual ay 2017, ano yung ginagamit nilang manual before 2017? Wala pong manual, pero may implementing rules and regulations that came into effectivity by 2014 at nag-start sila mag-release ng mga preso during that time. Sabi ni KGBP uli, sabi ni Gordon, dapat daw sinabihan sila ni Fildon sa problema sa batas para magawa ng paraan. Bullshit. Okay. You're right. You're right about the bullshit part. Hindi si Yusek Fildon ang magsasabi nun. And in fact, it was Secretary Maynard Guevara who rescued it and said, no, ito yung mga kailangan eh. So, he enumerated and he's saying that, you know, this is what we should be doing. This is what the law should reflect. As a matter of fact, there has to be a provision separate from Section 1 that says this whole entire law does not apply whether it is to all persons convicted of heinous crimes. Okay? Sabi ni Rodel Behasa, di po ba pwede na dapat i-deliberate din ang IRR bago ipatupad ang batas to make it streamlined? Kasi parang ang nangyayari, ang layo ng IRR dahil ba ito ang pagka-interpret ng law? Hindi naman malayo yung IRR actually. Hindi ako nalalayuan. What the IR and the manual are doing is operationalizing it. Now, you have to be careful when you use the term interpret the law. Kasi under our Constitution, only the Supreme Court, only the courts, can interpret a law. When we say interpret on the part of the executive, ang sinasabi natin is, ito yung basa nila. Kung paano nila i-execute yung batas. Okay? Because an interpretation of the law is actually done only by the courts. Yung basa nila as to how to operationalize the law, actually, I don't see anything wrong with it. Kasi, ano nga bang sasabihin ninyo? What constitutes good conduct? Para sa akin, tama yun. You haven't violated the rules. Kung gusto nyo, dagdagan ninyo. Like, yun nga, mag-aaral ka, tutulong ka, etc. What will be the objective standard for that? Well, sa kulungan, malaking bagay nga po yung hindi ka napipinalize for violation of the rules. Ngayon, ito yung sinasabi ng iba, especially dito kay Senator BG, whom we love dearly, but I think he was mistaken. Kasi yung sinasabi niya, good conduct ba yun, nahulihan ka ng droga, nakasaksak pa dun sa Mama Mary, na dati mong niyayakap? Okay, pero the law states that the computation of conduct is based on a monthly evaluation. Hindi yung evaluation ng buong stay mo doon sa kulungan, which I think would be more appropriate, but is already covered by another law, the law on paroles and pardons. Particularly the law on paroles, which is a very old law, it's a Commonwealth Act. Ang point dito is, doon sa good conduct time allowance, good conduct is simply being able to stay within the bounds of the rules while you are in jail. And that's okay, because once you go beyond the bounds of the rules, then that's no longer good conduct, di ba? Pero the evaluation should be extended, not just monthly, pero sige, monthly, bigyan ka ng good conduct time allowance as the law states. Pero an evaluation should also be made of your entire stay para matingnan natin kung ilang beses siyang nagbubulakbol, ilang beses siyang nag-violate ng mga rules. And if marami siyang violations ng rules, dapat wala yung Section 5 that says walang bawian dun sa good conduct time allowance. Okay? So, binabalik-baliktad ko na itong batas na to, kabisado ko na siya. And I see that it has its good points. Nakikita natin for rehabilitation of the prison population. May hope pa yung iba sa kanila. Kasi yung mga talagang desidido, magbabagong buhay ako, nakikita mo naman within the prison population. But the problem is dealing with the monsters. What do we do with the people who raped and killed somebody under really heinous circumstances? Do we consider them as reformable? Do we consider them as rehabilitatable? Kasi, base dito sa batas, walang distinction. Everybody is rehabilitatable. Diba? At yun ang gusto dapat natin. Yan dapat ang pinupuntirya natin when it comes to amendments. I don't think putting the blame on Bucor Chief Nicanor Faldon is going to help the victims of the families. What the Senate might be doing, sige, this is my opinion and my opinion alone, kung papagalitan ako ng Senado, o di sige, I think what the Senate is doing is really distracting us from the fact that this law has been in place for so long and nobody noticed that we made a law that makes it really easy for the prisoners to get time off for good behavior or to leave the prison setting, and there aren't enough standards to determine if this person has been reformed, and that I think is what is missing in the national conversation. Hindi napapag-usapan yung puntirya ng batas na ito, which is to reform and rehabilitate. Okay, it isn't dapat to declog the jails because you're just putting monsters back into the streets. We have to find out if these people, whether ikli lang yung sentensya o mahaba, tinitignan dapat natin kung talagang nagbago na ito and is society safe even if we put him back amongst us. Diba? Sabi ni Flexi D. Aurelio, dapat pag heinous crimes, death penalty na para di sila applicable. Oh, and by the way, may isa pang hindi natin napapag-usapan tungkol dito sa good conduct time allowance. Kasama sa mga heinous crimes po, ang plunder. O, di ba? Kasi dati death penalty siya eh. So, nandun din sa listahan ng heinous crimes siya. Why is this important? Because it is entirely possible na one of the reasons for the sudden interest in the Bucor chief's continued stay is that now, one of the reasons why this law might have been created was to benefit those who plundered. Mayayaman kasi yung mga yan eh, di ba? Nakanakaw ka na eh. Dami-dami mong pera. So, dahil meron kang plunder charge, technically, panghabang buhay ka na dyan. But, you might get to live pa to enjoy your money kasi kung may good conduct time allowance ka. Kasi you can get a lot of time off. Di ba? Sabi ni Marcos Macoy Alagon, ano po bang maaaring pagkakamali ni Faldon dyan sa issue? Akong nakikita right now. Except siguro, dun sa part na he allowed his deputies to sign for him yung mga release orders. Yun, I think that's a mistake, but it can be cured by his affirmation. Diba? Yun na nga, tama si Senator Gordon nung sinasabi niya na kung requirement ng batas, or was it Senator Lacson, na only the DOJ Secretary can sign an order of release, then only the Secretary of Justice will sign an order of release. But it doesn't apply to a memorandum order for release, which is done by the Bureau of Corrections Chief instructing only the warden, the Bucor to the warden, instructing him to release the person. The order of release, based on the recommendation of the Bureau of Pardons and Paroles, is signed by the Secretary of Justice. Sabi ni Rowena Rizardo Mendoza, ina-ask niya kung wala bang mga presong nabigyan ng GCTA. Meron nga po, in 2014, nag-start na po sila na mag-release at may ilan doon na heinous crimes. So, in fact, yun ang nahuli nating kaso dun sa Chu versus People of the Philippines. Si Chu was convicted for the sale of illegal drugs. So, alam natin na in-apply yung good conduct time allowance to heinous crimes and they were applying it also to drug dealers. Sabi ni John Su, up to now, hindi nga inaamin ni Sanchez yung crime and no remorse after so many releases. Guys, yung hindi inaamin, it's irrelevant after conviction. Kasi nakakulong ka na eh. It doesn't really matter anymore. Nagmamatter siya in court when you show remorse, when you show that, at saka nagmamatter yan pagka parol. That's one of those requirements for the determination of parole. Hindi siya requirement sa good conduct time allowance, and it is not, strictly speaking, a definition of good conduct. Even without the manual, hindi siya considered conduct that will merit the diminution of the service of sentence. Pero kino-consider siya sa parole. Sabi ni Sams Noel, bakit hindi ito dumaan sa BPP? Dapat dumaan siya. I'm not sure why you're saying that because lahat naman dumadaan eh. Sabi ni Oriel Villanueva, wala namang kriminal na umaamin sa kasalanan. Oh, there's that. Sabi ni Benjamin Escano, if the prisoner sentenced to 7 reclusion perpetual, sovereign committed, or released illegally, Jews do misinterpret, can be brought back to prison, let the SC decide their case. Actually, di ba in-explain ko nga, sinasabi ni Sec Maynard na that is complicated because they will claim their vested right. And right now, the law is in their favor. Magfa-file na, if they are kept in jail, ang gagawin, let's say, and I see this is what's going to happen, the DOJ will stop the releases of prisoners and not implement the good conduct time allowance for those who have been convicted of heinous crimes, pero may magfa-file dyan ng habeas corpus, and it will end up with the Supreme Court. That's how it's going to go. Sabi ni Ludi Gelbanyas, anong kailangan gawin dun sa batas? It has to be amended and a separate provision drafted according to Secretary Maynard saying that this does not apply to those convicted of heinous crimes. So, totoo yan. Secretary Maynard, namin nagsasabi kudos to Secretary Maynard. Oo, he was cool and he outshone everybody. Ang bait-bait nga niya kay Senator Zubiri when Senator Zubiri was saying, hindi pa pwedeng ikawaran ito. While I was watching, ganun ako. And of course, Secretary Guevara said exactly what I was thinking is that, probably grave abuse of discretion, but not co-warranto because co-warranto is actually an action to question somebody who is holding office. Co-warranto means by what warrant, by what order do you hold that office. So, hindi siya po mag-a-apply. Mag-a-apply siya to Supreme Court justices. Ganon. Sabi ni M.A. Badillo, sana di na lang muna tumanggap ng posisyon si Fildon. Di yan tatantanan ni Lacson dahil talaga mainit siya kay Lacson. Siguro na booking. Okay. Well, a lot of people are actually saying that. Sabi ni Randy Ramon Revilla, thank you. Informative talaga at madaling masundan ng pagdadala ng discussion. True. Yeah, guys, may ako nakikita ng comments ng galing-galing ni Sec Guevara. Yes, I agree. Agree completely. Cool, logical, law-based lahat. At saka, di ba, ang dali maintindihan yung mga sinasabi niya. And he was also very gentle with some of the senators who were asking really outrageous questions. And even under questioning by Senator Tolentino, whom I felt was being a little, was exceeding his boundaries, nung nagdidemand siya na si Secretary Maynard mag-submit ng proposition by tomorrow. I think that was unreasonable. Sabi ni Esmer Piamonte, do they need to include the manual of process sa batas? No, actually, the manual is a codification of the rules. So, you can make rules to execute a law. Sabi ni Carl Alexis Dasco, kahit patanggalin si Fildon, kung ganun pa rin yung batas, walang pagbabago. Correct. Sabi ni Rudy Camposano Bisco, as what Erwin Tulfo said, implementing rules and regulations made by De Lima and Mar Rojas are absolutely flawed. Hope they will be liable. Yeah, but most likely civil lang yan eh. Unless we can prove that they were paid to do this. Sabi ni Mateo Hamo, Rawon, lumantan, personal na problem should not be brought up during conversation. Unethical. What conversation are you talking about? Sabi ni Chuck Walker, thank you for your time and efforts to make us understand this issue. I'm constantly frustrated with the brains of those in the Senate playing blames and not admitting faults in this particular law. Sabi ni Emmanuel Caseñas, if the president leaves the whole country to you, that just proves how good a man you are. Yes, agree. Sabi ni Oriel Villanueva, Hontiveros nag-ask kay Bucor file doon kung kailan mag-resign. Yeah, we already talked about that. Sabi ni Josephine Velasco, so in the act, did it define po ang heinous crimes or at least mention where they gay? Well, there's a law that defines heinous crimes po. Sabi ni Flexi Aurelio Tolentino, pakitang gilas just now. Sabi ni Ray Generoso, nilampaso ni Sec Guevara ang mga nagmamagaling na senador. Siya pa ang hinihinga ng advice about legality and recommendations. You know, before Secretary Maynard became, he was deputy, what do you call this? Deputy Executive Secretary for Legal under the Aquino administration because he was so brilliant. But before that, he was a practitioner. So, alam natin that this guy is really, really good. Magaling talaga siya. Sabi ni Nelson Nivadura, hindi naman problema ang batas. Klaro naman ang taong nagpatupad ang may problema, hindi ayon sa batas. Disagree po ako. Disagree. Hindi po talaga. Kasi nga, nakalagay na po kasi nakapost na dun sa Luminous, yung binaklas na namin yung batas dito eh. Sabi ni Emmy Duran, di ba liable si De Lima dyan kung sa panahon niya ay may napalayang na di dapat mapalaya? Actually, we should have questioned it at the time. So now, nakalaya na sila. It's going to be really difficult putting them back in jail without violating the rights or violating the Constitution. Sabi ni Emiliano Cruz Gibana, sana si Sec Guevara na lang ang Executive Secretary. Agree, pero we need him in the DOJ eh. Finally, sabi ni Rod Rodriguez, what should we expect after this? Well, the Senate has to get back to work as well as the House to redraft or add to this law. I agree with good conduct time allowances. I agree with that in principle. I disagree that they should apply to those who are serving life. On the other hand, I disagree that we should apply it retroactively. Napakawala na, well, it's going to be difficult kasi without violating the Constitution. Sabi ni Fifi Fanelli, what's your take on Recto shooting himself and I did the roll eyes for second? We have the same reaction, madam. Sabi ni Jenna Reyes, sana you'll be invited by mainstream media to explain this law. Unfortunately, mainstream media pa rin ang source of information ng majority ng Pinoy ngayon and alam naman natin how biased they are. Yeah, but we still have social media, so we're good. Sabi ni Tolitz Pakides, di po ba iba ang releases sa completion of sentences sa releases in line with grant of executive clemencies? Di po ba only grant of executive clemencies like parole, commutation of sentence, pardon, and subject to approval of the President at kapag regular releases are within the authority of the Bucor? Yes. And in fact, good conduct time allowances, there's no provision that it goes through Board of Pardons and Paroles and then up to the President because it is not an executive clemency but an extinction of criminal liability. Sabi ni Al Alvars, among the incumbent senators and past, sino ang nag-endorse, disagree, and abstain sa batas na ito? I don't have the records on this one. I have the authors. Andrea Lee says, yung iba kasi di naman abogado, nagmamagaling sa Senado. Actually, it's painful to hear some of them discuss legal points. Like, gusto ko naman si Tito Sen, pero nung sinabi niya charged and convicted are the same things, they're not. And no court is going to say that. Charged means you're being called to answer for a crime. Sasagot ka. Convicted, penalize ka na. Pasok ka na sa kulungan. Sabi ni Websay, Bob, it seems to me mas lax ang GCTI compared to paroles. Yes, and I believe that the senators intended that laxness. According to Attorney Larry Gadon, ang purpose pala talaga nito was to be able to find a way na ma-release yung mga comrades ng mga kaliwa ng maaga because they were charged with common crimes like murder, gano'n, di ba? Pumapatay sila ng mga sundalo, yung mga grave coercion, mga ganyan. And since they wouldn't get in trouble inside since ganito kalax yung pag-determine ng good conduct time allowance, then extinguished na yung additional na criminal liability nila. At the time, ayon dun sa aming bubwit, at the time ginagawa ang batas na ito, si President Noynoy was after the Nobel Peace Prize or something like that, allegedly. At he was willing to give what the leftists were asking for in order for the peace talks to be fulfilled. So, yun daw yung basihan kung bakit naitulak ang batas na ito. So, it isn't that the law is vague. It isn't an act of stupidity or bad draftsmanship. So, binabawi ko na yung sinasabi ko dati noon na it's bad draftsmanship, one. And the second, sinabi ko kasi nag-a-apply ang that the heinous crimes provision can be read to apply to the whole law. Well, that's what it says, but it clearly indicates it applies only to the good conduct time allowance granted for detention prisoners. So, the purpose was to be able to allow certain prisoners an early release. Yun yung purpose niya. And unfortunately, dahil ang lapad ng lambat na yon, maraming nasama, including ito na ngang sina Mayor Sanchez. Sabi ni AJ Panun, pwede po ba maglabas ng lists and pics if okay para alam ng tao kung sino-sino ang mga nakagawa ng heinous crimes na nakalaya para aware ang mga tao sa kanila? I'm not sure if that's still allowed kasi nga, ang purpose ng batas is to put them back into society as productive members. And if you violate their privacy because you're concerned that they had been released early, I think we're going to run afoul of the Constitution again. Okay, so when I say run afoul of the Constitution, it's law speak for saying na baka lumabag din tayo ng batas habang ginagawa natin yan. Sabi ni Ardwell Magdamo, tama po, nililihis talaga nila mawala ang Bicoy, Red Santillan case, NPA case, PhilHealth scam, and BIR's tulay. Sabi ni Jomar Manyalak, dahil dyan sa good conduct, mas malaki ang chances na mapalaya ang sino man maging heinous crimes kaysa mag-apply o maghintay ng parol. Oo. Sabi ni Andrea Lee, si Kiko, kala mo naman magaling gumawa ng batas, haba na sinabi. Sabi ni Bong Herrera, the law was made just to serve for their dilawan own purpose and interest. Konting drama nga lang naman, makakalaya na sila without completely serving their time. Sabi ni Zams Noel, we need a Guevara in the Senate. Agree? I think we need a Guevara in the Supreme Court. But right now, I'm happy that he is in the DOJ. Kasi siya lang ang makakaayos nitong sistema na to. And you know what? He's so vastly different from Laila de Lima as Secretary of Justice. Diyos ko, kalayo. Sabi ni Althea Ori, bakit hindi ba allow tanungin si Senator Bato? That time siya in Bucor, may nakalabas ba ang mga halang ang kaluluwa? Well, you know that Senator Bato ceded his time to Senator Bongo, and I think it was because he wanted to avoid unduly being noticed for this because he was the former Bucor chief. And my concern is that I was hoping that he would speak on behalf of the DOJ and the Bucor and present a more nuanced and objective view of how it went on down there. It isn't about, kasi ang gusto ng mga senador, gusto nilang palabasin na may corruption dito, nagkabayaran dito, when actually all they were doing was implement the law. Now, I'm not saying walang corruption. I'm not saying walang bayaran dyan. It's early to tell. Pero just from the actions of the Bucor and the Secretary of Justice, ina-apply lang nila itong batas na to. Ngayon, bakit sila nagpalabas ng ganitong klaseng batas? Kung magagalit sila na may nagpapatupad. Diba? Sabi ni Andrea Lee, bakit noon may kubol sa Bucor, tahimik ang Senado? And that's an excellent point, di ba? Sabi ni Hector Padligo, nag-due process naman kasi sila. Tama ba? Dapat baguhin ang batas. Yup. Okay. Now, i-recap lang natin, ha? There are two rights that are being balanced out here. The rights of the victims to see that the persons responsible for hurting them or hurting their loved ones are taken out of society. Okay? And the rights of the convicts and accused to their own freedom if the law has already granted it to them. So yung dalawang very important rights na yun, binabalanse natin. And that is what the DOJ is trying to do. Because the Constitution guarantees the protection of those two rights. Ngayon, kailangan i-determine nila yon as quickly as possible because they can suspend the execution of the law only for so long. Alam niyo kung bakit? Kasi once natapos na yung term ng isang preso, and assuming that it has something to do with the good conduct time allowance, you cannot hold him beyond the period of the lawful incarceration kasi once lumampas na, meron ng liability for serious illegal detention yung prison authorities. Now, they're lucky kung pakasuhan lang sila ng habeas corpus para isoli nila yung tao into society or release nila. Mas matindi kung kasuhan sila ng serious illegal detention, which essentially is kidnapping. Okay? So, yun ang nakikita natin na pinoproblema ng DOJ at saka ng Bucor. Hold them too long, you get sued. You become a criminal for serious illegal detention. Let them go too early and you might be putting a monster back on the streets. So, we have no answers right now. In fact, the DOJ was saying, Secretary Maynard was saying, we have to be looking into this carefully because this is a sensitive matter that involves the Constitution. So, yun lang po muna. Bukas may karambola pa and we can explain this further with more questions coming from you. Maraming salamat ulit sa pagsubaybay sa amin dito sa live na ito. Don't forget to like and share and follow dito sa Luminous and don't forget to subscribe to our Facebook lives. Maraming salamat pa. We'll see you on Karambola tomorrow, 8 to 10 ng umaga.